It's impossible to talk about these possibilities without considering ethical issues, including addressing security and privacy concerns, and requires a careful consideration of the legality behind conducting the research, developing the infrastructure, pursuing business opportunities related to data access. So with that preamble, it's my pleasure to introduce our first keynote speaker, Dr. Michael Geist. Dr. Geist is a law professor at the University of Ottawa and the Canada Research Chair in Internet and E-commerce Law. Dr. Geist holds a bachelor's, 2 master's, and a doctoral degree in law. He has received over 15 honors and rewards for his accomplishments, including Canada's Top 40 Under 40 in 2002, Canadian Lawyer 25 Most Influential Lawyers in Canada for 3 consecutive years, 2011 to 2013. His work focuses on intellectual property law. He's also a major contributor to the development of the Internet in Canada. Dr. Geist has a regular column in the Toronto Star, the Hill Times, and the Tide. He has written 3 books and has edited 3 others, and Dr. Geist is active on many national and international boards and committees. So please join with me in welcoming Dr. Geist to the stage.
Great, well, thanks very much, and thank you so much. Thank you so much for the invitation to come and speak. It's great to see so many people interested and so enthusiastic about open government, open data, and those kinds of issues. So as you can see from the title of my talk, I want to talk about not so much the negative, but talk a bit about what sometimes can be obscured or hidden in our enthusiasm for open government. And I'll start from the perspective that what's not to like, right? So this comes from the Tony Clement, the Federal Open Government Initiative most recently. And you can see here it talks about how you can explore how the government is working, greater transparency, accountability, more citizen engagement, better innovation. I mean, who wouldn't want those things, right? And so there's, I think, tremendous amount of enthusiasm, certainly with the public, within government, about the potential that open government brings, about the potential that opening up the data sets brings, and we've already heard some really exciting examples of that this morning. Now, as I mentioned, I want to bring in, I guess, a little bit of a word of caution, not to suggest that all of this isn't great, but that if we don't get some of the challenges and issues that I think arise as part of this right, those issues themselves, I think, are a source of concern, but perhaps even more, the likelihood of seeing this come to fruition in the way that I think many hope and expect, I think is also imperiled. So let me start with a story of Thelma Arnold. And so this isn't an open government story or big, open data story, but it is, I guess, a big data story. Thelma Arnold, a number of years ago, was a retired senior living in Georgia in her 60s. When she got a phone call from the New York Times asking her about a whole series of search terms that she had put into AOL and asking her if this was in fact her. It turns out that it was. And the background of this particular story was that you have to think of a time that AOL was actually a big relevant search company, which I know was a little bit a time ago. But nevertheless, there was a time when AOL was a major player. I mean, it's still a large media organization today, but it was a major player. And their ability to track their user search was in some ways a little bit different even from Google. Google, of course, can track individual users if you choose to log in, but in AOL's case, they're active subscribers. You logged into their network. They could see on a user-by-user basis what they were doing, including what they were searching for. Now, in this instance, AOL had the best of intentions, as we often do in the context of things like around large data sets. They said, we want to try to take much of those search terms and the search activity and make it available to researchers. Let's find ways to improve the quality of search by handing over that very large data set. And of course, they will, as we heard in one of the earlier panels, we will ensure that there's anonymity here by taking out the particular names of the subscribers. And so for each subscriber, they simply had a unique identifier along with all of their particular search terms over a given period of time. I think it was 6 or 9 months. Now note that what they wanted to do was to be able to provide insight into particular users. I mean, they could have handed over just, here's all the search terms and got rid of the individual profiles, but there would have been something lost in the process. There's something instructive and potentially valuable about seeing how people search and what they search over time. There's also, it turns out, a lot that you can learn about that particular person, including ultimately, in many instances, their identity. Think of what you search over a 3-month period or a 6-month period and what it might say about you as you think about the different kinds of things that you search. I mean, some things, of course, might just be something sports related or movie times or something like that, but there are, of course, the vanity searches, which are, I guess, a bit of a dead giveaway, but you might search things around family, you're searching things that are in your geographic area from a location perspective. There's a lot of that taking place, and so too in this particular instance. And so when they took a look at the kinds of things that Thelma was searching for, it became pretty obvious that this was in fact Thelma Arnold. She was interested in dogs, and she lived in this town in Georgia. And it wasn't that hard. The reporters at the New York Times said they were able to uncover who this was fairly easily, and they were able to do so for many other of the people. Now, the response of AOL, unsurprisingly, was to pull the data right back, to say, okay, well, there is a privacy concern that we didn't properly address, and so we're going to take all of this back, which in turn led those engaged in research on search to say this is an enormous loss. We had great potential here, and yet we've found a way, we've now lost access to this kind of data. To me, this is in some ways illustrative of the challenge that we face when it comes to open data. The great potential that much of this brings alongside some of the risks as well. So I want to talk about some of those risks in particular, and I'll start with privacy. And in this instance, just by providing some amount of context, note that there is, of course, the Open Government Partnership, OGP, which Canada is a part of. Indeed, there are now dozens of countries that are participants, and there have been thousands of commitments. And so we see now there, as part of the Open Government Partnership, an initiative started several years ago with, as I say, now about 65 different countries who are active in terms of making commitments towards open government. That, of course, includes open data, but it can go even beyond that. And there have been, as part of that, thousands of commitments, and Canada has been an active participant there as part of the shift at a federal level, that shift towards open by default. Privacy, for the most part, doesn't really appear. We've got 17 references to privacy in the roughly 2,000 commitments, with 10 of those including commitments that bear some amount of relevance to privacy. And so for the most part, in this rush to try to bring new commitments towards open government, many of which I think are terrific and terrifically important, for the most part, privacy hasn't been part of that balance and that discussion. In fact, privacy hasn't featured significantly at all. And so we need to think, I think, a little bit about that. And so my first issue that I think comes up, that first concern, is indeed around privacy and anonymity, highlighted by the Thelma Arnold story, but there are, I think, many others. And this question came up directly in one of the earlier panels this morning. And of course, the response was, and I think quite rightly so, well, of course we have to ensure that this doesn't affect someone who might be vulnerable to the access to that information. But if you tell that to this person here, Latanya Sweeney, who is a researcher at Harvard, she'll tell you that she's not going to buy into the view that it's so easy to anonymize this information, particularly highly sensitive information. She came to my attention through a case involving this newspaper here, the Southern Illinoisan, I think that's how they pronounce it, in Illinois. And what they were looking for was data. This is a case from a little over 10 years ago, or early 2000s. And the state had a cancer registry. The paper wanted access to the cancer registry, seeking 3 pieces of data that were readily available within that registry. First, the type of cancer. Secondly, the diagnosis date. And third, the zip code of the individual. And from the paper's perspective, this what could be critically important information. I mean, we talk about how this kind of data, especially in a health context, can identify trends. Well, it can certainly identify trends looking ahead, but it can also identify trends or issues that may have been occurring within our communities. And so in this instance, they were actually interested in a very specific kind of cancer that is terminal and is particularly vulnerable for children. And there was some fears that there might have been environmental spills or damage in certain parts of communities. And so their hope was to say, if we can identify by time, diagnosis date, zip code, area, and type of cancer, this particular kind of cancer, we can identify whether or not there might have been some kind of connection between a particular environmental issue in one community and resulting cancers in that community as well. Well, I mean, this is immediately obvious that this is valuable information, right? This is the sort of thing that we would want to see data mined, in the sense that if we can identify that, there's enormous amount of value to the community. The concern in this case, particularly given the fact that the cancers at issue were cancers that affected kids, was whether or not this baseline data, these 3 pieces of information, might ultimately lead to identifying the kids at risk. Now, LaTanya Sweeney at the time was at Carnegie Mellon University. She's now at Harvard. And so she was brought in as an expert to try to determine whether or not this de-identified information, it's just 3 data points with nothing about particular individuals, could in fact identify those individuals. Sweeney said, give me the afternoon, I'll give you the names. And so in Sweeney's case, she said it's not so much these particular pieces of information, it's all the other information that's readily available. So you go, for example, she's talked about how in a couple of instances she was able to identify a couple of the kids by going on chat forums where parents who have children that are facing terminal illnesses go on to talk about that. Well, in those instances, they're often much more willing to identify who they are, or can be more easily identified. And by starting to pull 2 and 2 together, or I guess more accurately, taking those various pools of information that are out there if you know where to look, and bringing it all together, she was in a position to identify these particular kids. Now, in this case, the court actually ultimately ruled against the government, which didn't want to release it, and they had used Sweeney as the expert. They argued Sweeney was so expert that the average person wouldn't be able to identify those people in the same way. But that was a long time ago, right? It was more than a decade ago, when some of the kinds of tools that one might use to, in a sense, put Humpty Dumpty back together again weren't nearly as pervasive and weren't nearly as effective as they might be now. And so those kinds of concerns about the ability to re-identify what is otherwise de-identified data represents, I think, still an enormous challenge for us in the world of big data. So Sweeney has been active in a number of other instances. In fact, I think she became first prominent in the case of William Weld, who was the governor of the state of Massachusetts, whose health information was also contained in some of these databases and was ultimately identified from otherwise anonymous data, based again on a number of different other publicly available databases. And so from Sweeney's perspective, it doesn't take much. Birth dates and zip codes and gender, she says, allows you to identify between 70 to 80% of the US population. Now, that's not necessarily replicable here in Canada in precisely the same way. We haven't made some of our health information available online in the same way that they've made it available in the United States, but we can already see some of the interest in trying to do so, and as I say, for very good and understandable reasons. But we have to, I think, go into that with our eyes open. There are risks, and in fact, Sweeney's been engaged in other instances as well. This is a particular instance fairly recently about so-called anonymous volunteers in a DNA study also being able to be identified once you have enough pieces of information. Things are more identifiable than we might think, and especially in some of the smaller communities, let's say out here in the eastern part of the country, where the communities some of the cities are smaller. If you've got an outlier condition or an outlier issue that isn't typical within the population, you aren't as anonymous as you might otherwise think, so long as we happen to know the particular geography. Now, big data can raise some other issues as well. We've seen some of the tremendous possibilities around mashups and the like, but there have at times been backlashes as well, oftentimes arising through that prospect of data that is otherwise anonymous being re-identified. So we saw it in California earlier in the last couple of years under Proposition 8, same-sex marriage legislation, where donors in favor were mapped, and again, there was the prospect of identifying, and some privacy issues came up there. In the United States, a similar one where a newspaper tried to take gun ownership issues and map some of that, also resulting in a backlash. But we shouldn't think this is just a US issue. We see it here in Canada as well. I'm on the privacy panel after lunch, and I'll talk a bit more about CANLI, the Canadian Legal Information Institute. I sit on the board of CANLI. It's the body that's actually funded by lawyers across the country to bring legal material, make legal materials freely available online. And so we work with courts and tribunals across the country to make all those cases openly and freely available. I think that's a great thing from an access to justice issue. But the challenge, of course, is that we've got lots of family law cases and other highly personal cases that raise the kinds of things that people might not want to have made publicly available. Now, for a long time, the approach of CANLI was in family law cases to try to remove some of the identifying information, and in other cases, simply trying to use a little bit of obscurity. And so at the approach, in a sense, was we won't be quite as popular as we otherwise might be, and that will protect a little bit the privacy of people whose decisions may be in these otherwise public documents. And so, for example, most courts preclude CANLI from having Google index these particular decisions. And so if you run a general search for most of the decisions that are hosted in CANLI, and there are millions of them now, you won't find the overwhelming majority of them in Google because they're not indexed. But it is still open, and as a board, we're anxious to be open generally for open data purposes and to have it used. The problem that we ran into was when a Romanian site captured hundreds of thousands of these decisions and began posting them online, and they were not quite as reticent about having Google index those decisions. And so what happened was, and it is still a live issue, is that for the first time, many people became aware that these decisions were actually available online. They hadn't heard of CANLI either, or weren't aware the decisions were out there. They became aware of it through this Romanian website. And when they contacted the website said, sure, we'd be willing to take it down. Here's the fee that's involved. And so this is, in a sense, a kind of sleazy, not kind of, a sleazy money-making attempt to try to capture lots of these decisions and essentially force people to pay if they want those cases removed. At the same time, though, they came to CANLI and said, well, why are these decisions out there in the first place? And then you have to get into a bit of a debate and discussion about open court principles and explaining that these decisions are public documents and otherwise available. But there is a real challenge there, again, in striking that balance and recognizing that data that is publicly available, right? I mean, you go to the courthouse, you can get any of these decisions. But once we make it more broadly available and potentially available for data mining purposes or other purposes, new challenges can emerge. Now, somewhat related to the privacy issues, of course, are surveillance-related issues. And so it seems to me it is very tough to talk about open government and this notion that we are suddenly now open and not think about Edward Snowden and the sorts of revelations that we have seen over the last now year and a half. I'm sure everybody has tracked to a certain extent. It was, in a sense, a little bit hard to keep pace, but we have learned that everything from phone records to data mining of data that's coming through all of the largest internet companies to other attempts to capture these kinds of information, capturing email records, as you see. I'll just go through a bunch of things. Searching the content of the messages themselves. So notwithstanding repeated assurances that surveillance agencies were not interested in the content, they were focused instead on the metadata associated with messages to develop some kind of social graph. We learn instead that the reality is that in many instances, the content itself is being tracked, and there is surveillance there too. All of this being spent with billions of dollars that is largely in a black box about which we know little. At the same time, attempts to cover some of that up, so much for open governance, and of course lots of spying activities too around the world. I mean, I suppose spies are going to spy, but we learn the extent to which the NSA has been engaged in that, and sometimes paying for some of that funding too. And so particularly the NSA funding for the surveillance activities, not just in their own country, but in others, including our own. And so if you take a look at the budget of the CSE, which would be the Canadian equivalent to the NSA, you'll find that one of the line items is revenues that they get from foreign agencies. They don't name the NSA, but it's pretty obvious where that money is coming from some of the programs that Canada happens to be engaged in. And then I think somewhat remarkably, the effort of the NSA not just to engage in these sorts of activities, but also to even undermine some of the very security that we rely upon. And so when we talk about, well, okay, one of the things we are going to do to provide better assurance is to ensure that the communications themselves are secure through encryption mechanisms. We learned over the last year or so that the NSA, with Canada's active participation actually in that instance, was working to undermine some of those standards. So we've been a player in some of this. What about Canada? We've been there too. And of course, if you've been following along the Canadian specific stories that have come out of Snowden, you know that we have our own spying and surveillance stories as well, little from an oversight perspective, but even more data collection programs focused on metadata that are basically a blank check to capture as much metadata as possible. I appeared before a Senate committee just last week on Bill C-13, the Lawful Access Bill, and one of the focal points was trying to explain that that metadata can be just as illuminating as the content of the messages themselves. And yet the approach that the government takes in this particular bill, in Bill C-13, is that it has a lower standard. There is a lower threshold for the purposes of obtaining a warrant. So we are engaged in some of the same kinds of activities as well, from a spying perspective and a data capture perspective as well. And so when you think about our role in some of this, I think it's important to recognize that open government is great, and it's wonderful that Tony Clement and others can get up and talk about how we are going to be transparent and open. But I must say it becomes rather difficult to truly fully buy that notion when we learn about the other side of what is taking place. There is no transparency. There is no openness around this. Indeed, we know now that these kinds of activities have been taking place for years without any real effort to inform the public about what is taking place, and even where there are attempts to access that kind of information. The court cases themselves often are held in secret. The information itself is ultimately redacted in many instances as well. I'd argue that represents an enormous problem if we're trying to be serious about some of these kinds of issues. Closely related in a sense to that openness of government, of course, is access to information. And there, in some ways, there are many that may confuse the two issues. They think on the one hand of open government, and they think that somehow it naturally follows that our access to information system will be equally open and equally accessible. And while there have been some efforts, I can speak at least at the federal level, to trying to make it easier to apply for to file access to information requests, with some moves to make them electronic, and some efforts to at least list the various access to information requests that have been completed. The reality of the situation, at least at the moment, is that this is a system, for anyone who has used it, again, at least at the federal level, that is almost completely broken. Our information commissioner at the federal level is going broke. There is not enough money for that office to even conduct the investigations where there are appeals on this particular issue. Cases that are supposedly under the law supposed to take 30 days with the prospect of an extension, in some instances take years before you ever get any of the information that you've requested. And in those kinds of situations, the importance of the issue, or the relevance of the issue, has faded largely into obscurity by the time you finally get some of that information. We rank poorly on those kinds of issues. I think it's worth noting. And so while we often talk about how well we may rank, I heard top 5 earlier in terms of some of the kinds of things that we're doing. And it is true that when you take a look at what we do from a ranking perspective on things like the Open Government Partnership, we do well. We're one of the first to move, for example, to open and open by default. But if you then take a step back and take a look, how are we doing for this other set of government information? We don't do so well. In fact, within governments, even at a provincial level, sometimes we do quite badly. This is from Ontario. It's a story just in the last couple of weeks out of the Toronto Star, where one reporter was seeking to obtain information on the cost related to the Pan Am Games that will be held in Toronto next summer. The bill associated with this was in the thousands of dollars almost all of it related to copying costs. And so when the reporter said, well, I'd like this electronically instead to remove the need for copying costs, the answer was, we won't provide this to you electronically. You have to get it in paper form, and we have to charge you per page copying cost. There is no consistency, at least within Ontario, and this is true at the federal level too, no consistency with respect to whether or not you can obtain these documents in electronic form or they have to be in paper form, and further the kinds of costs associated with that. So there are, I think, real problems, and ultimately this speaks to, at least from my perspective, the notion that I don't think transparency is not created equal here. You know, just because you make large data sets available about the weather, about other sorts of things, I mean, these are important and interesting for some people, that doesn't make you transparent as a government. And indeed, I think the real litmus test in many instances for transparency in a government is not the information that government willingly says, here, go ahead, large data sets, knock yourself out. It's the information that they seem somewhat more reticent to provide, but which we are otherwise entitled to under law. It is the access to information, where we still find numerous barriers, sometimes cost-related, sometimes technical, sometimes within the law itself, sometimes the resources that we put forward. And I would argue that there is a danger. What open government hides, in a sense, is that if we say this is now an open government, but we don't get that other side of the coin right, in terms of access to information, that other kind of information, it's not truly an open government, I wouldn't argue at all. Now, I'm sometimes accused of not being able to give any talk without talking about copyright, and that's kind of true. And so one other concern that I have associated with open government is copyright, or more specifically, the licenses associated with open data that come out of open government. And there has been gradual attempts to try to get this right. But I think we should recognize that in Canada, we start from the position of Crown copyright. Unlike the United States, for example, where if it is government data, it's openly available and there's no copyright associated with it. Here in Canada, we have Crown copyright. The government owns the copyright in the work. Now, I think that's a problem. I think the whole notion of Crown copyright, somehow that the Queen owns this information, I'm going to say with respect, is simply an outdated concept, and that this information should be out and openly available. One of the problems that we face, though, is that we are trying to address the issue through a licensing mechanism rather than by removing Crown copyright altogether. And so the solution that we've seen come from government is to say, okay, we also recognize Crown copyright is a bit of an issue, and so what we will do is create a license that will allow you to use this work and make it openly available. Now, even in the open data context, this is now the license that the federal government has offered, but even in the open data context, the first license that was offered up under the Clement initiative at the federal level was still fairly restrictive. And so it opened it up for non-commercial purposes. It didn't open up the use for commercial purposes. So we have a panel devoted to all the commercial potential of this open data, and a license that just doesn't match because it's a license that still requires permission if you want to make commercial use of this information. Now, we've started to see that change, and so the newer license is a more open license that we see coming from the federal government. But I think there are still two issues here. We've got inconsistency of licenses across the jurisdictions. And so when you start thinking about, okay, what can I do with this data? The answer may differ if you are using federal information or different provincial information or municipal information, because not everybody is adopting precisely the same license. And so there may be licensing restrictions that you face. But then, so that's one problem. And then secondarily, I would argue that we had an opportunity, still have an opportunity, to address what, from my perspective, is the real issue. It isn't the license itself that's the issue, although it is there as an issue. It's the fact that we still have a Crown copyright system in place. A far better approach would have simply been to say, we don't need to solve this through a license, we need to solve this by actually removing the Crown copyright associated with these works altogether. But that's something that we haven't seen happen yet, and I should tell you that this is not just sort of an academic, copyright egghead issue. This comes up in all kinds of circumstances. It comes up in the Canley circumstance when we want to publish not case law, but rather statutes from various governments, because the governments in a number of provinces still take the position that not only do they own the rights, the Crown copyright in the works, but they seek to restrict public access to those statutes, which I mean would strike people as rather ridiculous. How could you not make available the very laws that govern the jurisdiction? They make some of those laws available, but if you want to be able to trace the evolution of laws, see earlier versions, that is seen as a money-making opportunity, and they don't want to make those versions freely available. They're able to essentially assert those rights over literally the statutes that they're passing by virtue of Crown copyright, and I think that the time for that to go has come. Now finally is the last major issue that I want to touch on. In some ways, to me, this is the one that rings the most important when we talk about the open government side. So open data side, I think there are the privacy issues that I highlighted, and the differential treatment of data between the data that government is happy to make available through open data initiatives and the data through access to information that they're not. But open government, when we see how it is operationalized in a number of jurisdictions where they talk about using these same kind of tools to try to engage the public and make them more active, part of the policy process through active consultations, is in theory a terrifically exciting opportunity. It's not just in theory, it is a terrifically exciting opportunity, and we have seen real world examples of how that has happened and can help influence policy. I think that helps make for a more engaged, active society. I think it's a better democratic society. I think there's so much to be said for finding ways to use these new kinds of technological tools, not just for outreach, not just for sort of here's what we're doing and making you aware, take a look at our website, but rather developing much more of a real conversation between the citizens themselves and the government and the policymakers, and a chance for some real activity. And so in the last number of years, we have seen a flowering, a mushrooming of online consultations. It seems like, and again, just some federal examples, everybody wants to talk and hear what you think. And so that sounds really good. So the CRTC, for example, is still engaged in reform of television broadcast regulation, and it literally called its process the Let's Talk TV consultation, and found a number of fairly innovative ways to try to get the public engaged. We've seen the Privacy Commissioner's Office do the same thing at the federal level with consultations where they went to communities across the country to try to do the same kind of thing. The Competition Bureau, the regulator on competition issues, literally just a year or so ago, put out a consultation to say, what do you want us to advocate for on your behalf? In a sense, what are the marketplace issues that you're concerned with that you think the Bureau ought to be engaged in? And so you look at this and say, this is fantastic. The problem, I would submit, isn't so much in the consultation. We've actually seen some really creative ways to try to engage in those consultations and get people active. The problem comes when the government gets that feedback but had a preconceived idea of what it wanted to do in the first place. And so what it is really engaged in is not consultation, but consultation theater. The notion that we are happy to ask you what you think, we are far less interested in what you actually think, in terms of taking that information and doing something with it. And so we've seen that too, right? So again, my copyright resurfaces. The government, and I was actively engaged in this, launched a copyright consultation in 2009 after large numbers of people spoke out against some of the earlier bills. There was sort of a lot of hue and cry. That was something I participated in. And so the government's first response was like, okay, let's consult now. Rather than going forward, we're going to ask people what they think. And I think to the surprise of many, even within the government, people showed up. So they didn't do a very good job, frankly, of collating that information and making it available, but I did. So I worked with students as we went through all the submissions, and as some of you may know, you can put out a consultation, and if you get 50 or 100 submissions, you'll get the couple of usual suspects who are most directly affected. You'll get a few citizens, and oftentimes that's about what you get. This copyright consultation got more than 8,000 participants. It did really, really well, I think, and this was over a summertime period. The problem, and it's not that the government didn't listen to anything that they had to say, but if we went through the things that got the most amount of response, and it's actually, I think, the item that's third from the top there, submissions against anti-circumvention or in favor of limiting digital rights management or digital logs. And this was sort of, for many citizens, the key issue they were most concerned with out of copyright. If you're non-technical, you're like, what is this even about? But it essentially came down to locks that we find on things like our DVDs or electronic books, and restrictions in what people can do with the very products that they themselves have purchased, seeing it as being unfair to limit what you do with your work, especially if what you were planning to do is something that was within the law. So if you're a teacher of media criticism and you want to take an excerpt out of a DVD and use that as part of your class, the proposal was that the law would restrict your ability to do that, even though the right to use it was perfectly fair. It was a permitted use under the Copyright Act. And so when we got the legislation a year later, it's actually, and it's now passed, it passed in 2012, it was on the whole a pretty good bill. There was actually a lot that the public had spoken out on that over time the government had changed. But on the number one issue that the public did speak on, the government didn't listen at all. It didn't change anything in this particular context. Now, that's politics and policy making. I understand it's striking a balance and the like. But I have to say that in many instances, I heard from people, in part because I was a bit of a public face on some of this, I heard from people, especially younger Canadians, who chose this issue to become the very first issue they got engaged in politically. People who would write to me and say, I'm going to meet with my member of parliament for the first time, and you know, I had to even figure out who my MP was. And they did that, or they wrote. And what did they get back? Typically, they got back form letters from the government that had almost no correlation to what they had written about in the first place, and they ultimately got a decision that they said they felt that their advice had largely been ignored. And I heard from some of those same people, I'm not making this up, I heard back from them afterward, and a lot of them was like, well, why bother? You said, get engaged, talk to a member of parliament, try to influence policy, and I did. And the government didn't listen at all. This was all just theater. They were just trying to give you the sense that somehow they were listening, but ultimately they weren't. We see the same kind of thing take place, I would argue, under lawful access. So you'll recall quickly that it's now back in 2012, yes, 2012, February, where Vic Taze was the minister at the time. He introduces the day before Valentine's Day the legislation, I always have to look it up for the name, the Protecting Children from Internet Predators Act, despite the fact that the word children only appears in the name of the bill and in one other spot in what's otherwise a 100-page bill. This was really more about surveillance and so-called lawful access related issues. You may recall that Taye's response was in the House of Commons the day before when questioned about this. He said, well, you can either stand with us or you can side with the child pornographers, which was how he framed it. It turned out that many said if that's the choice, they'll take the child pornographers. And so in this instance, the government didn't actively consult, at least not in this particular instance, but people didn't bother waiting for a consultation either. And so in this instance, we had hundreds of thousands of people write in and voice their concern about this legislation. And so that earlier one was from an NGO. This actually comes from the Ontario Privacy Commissioner and Kavukian. This page here is from the Liberal Party. So there were any numbers who were actively engaged, and it wasn't just petitions and things like that. There were any number of grassroots efforts as well. I'm fond of saying that my favorite of this, I reference it all the time when I talk about lawful access, was a Twitter campaign called Tell Vic Everything, where people would tweet things out with the hashtag Tell Vic Everything, with the idea being that if the government was going to engage in this surveillance, you might as well just tell them everything anyway. My favorite one of these tweets is this one here. Hey Vic Taze, I lost an email from my work account yesterday. Can I get your copy? It's still good. So who says you can't do a lot in 140 characters, right? I mean, this is both funny, but also conveys a message really effectively, and this was retweeted thousands of times. So much so that by the weekend, this was midweek, by the weekend, Taze appears on the CBC radio program, The House, and is asked specifically about this campaign and these kinds of efforts. And Taze says, he finds it really funny. But of course, if you're a politician and they are laughing at you rather than with you, you're sunk. And so in that instance, in that story, within about a week and a half, the government hit the pause button on the legislation. They made it clear, at least through leaks to the press, that they weren't, at least at that stage, going forward with it. And then a year later, we had the Justice Minister come forward and say, we're not moving forward with this anymore. Bill C-30, the online surveillance bill, is dead. And Nicholson says, any attempts that we will continue to have to modernize the criminal code will not consist of the measures found in Bill C-30. And so that should be actually a really good consultation story. In fact, the public didn't even wait to be consulted. They came forward, the government listened, and they pulled the bill back for 6 months. And 6 months after Nicholson says it's not coming forward again, Peter MacKay comes forward with a bill now under the wrapping of, in this instance, cyberbullying, but containing many of the same kinds of provisions that the government had just finished saying they weren't going to come forward. And that same kind of, in a sense, almost participation exhaustion, the cynicism that arises from people that say, this is just politics, there is no point. On this particular bill, which has now passed the House of Commons, and it's the bill that I appeared before the Senate last week, people didn't speak out in the same way. And when you ask why, many of them said, what is the point? We spoke out. We thought actually that the government listened. It pulled back on this particular legislation, but that lasted less than a year. 6 months later, not the same bill, but many of the same kinds of issues come up. And so the danger in all of this, I would argue, is that if you move forward with open government and say we are going to consult, you have to mean it. It can't just be an exercise in being able to say we were the open, transparent, consultative government that gave people the opportunity to speak out. If you don't, if all you do is give that opportunity to speak out, but then don't actually process it and somehow imbue it into your decision-making process. Not to say that you do what the public says every time. Let's recognize that's not how policy gets made. But leaving citizens oftentimes truly disengaged from all of these issues, I think has the potential to cause an enormous amount of harm. So I'll conclude by noting that there is, of course, a lot to love about open government and open data. It really does offer up some tremendous opportunities, and it truly is, I would argue, something that is so deeply connected with new technologies in a connected society. It is something different in a way that wasn't the case in the past when data might have been available, but you couldn't work with it in the same kind of ways. You couldn't reach people in the same kind of ways. But if we don't get these other issues right, again, just as I noted at the top, I think we run the risk of not just the risks associated with these problems, our privacy and disengaged citizens, but I think we ultimately run the risk of undermining the very effort around open government and open data itself. So when Tony Clement announced his latest open government initiative just a couple of weeks ago, this was the editorial from the Toronto Star, Tony Clement's Orwellian open government plan. Now, I know it's the Toronto Star, and I write for the Star, but nevertheless, it's got a particular political point of view. But their point in this wasn't, I don't think, to try to score politics per se. It was to say you can't talk open government on the one hand and leave your information commissioner for access to information broke on the other. You can't talk open government on one hand and engage in the kind of surveillance that Snowden has revealed on the other. And you can't talk open government on the one hand from a consultation perspective and then ignore what the public has to say on the other. I think we need to embrace the opportunities that come from open government and open data. Well, we got to get it right. And that means more than just saying, here's the data sets, go at it. It's taking these kinds of issues seriously and working through some of them at the same time. Thanks very much for your attention.
Hi, Dr. Geist. So it sounds like anonymization, etc., that's probably not going to work very well in the future. Given that, what can you tell us about the efforts to enforce punishments when it comes to privacy breaches, when private data is being used illegitimately or for the wrong purpose? Because it looks like while the laws are supposed to be in place, the punishments don't seem to be meted out. Mm-hmm. So on the one hand, we've got to make sure that we only use information the right way, but we're not really slapping any hands either.
Yeah. No, so it's a good question. So the issue of, well, if we are going to see breaches, and we clearly do see breaches from time to time, what kind of rules are in place to try to mete out some kind of punishment or enforce on some of those powers? And the answer, quite frankly, is that they remain rather weak. In fact, it is still the case in Canada at a federal level that we don't have mandatory security breach disclosure rules. So rules that are commonplace now in the United States, and we see it in some other jurisdictions where an organization has suffered a security breach, so the information is put at risk, you're required to disclose to those who are affected. And that's, you know, it's actually, the idea itself came out of Bolt Law School, came out of law school in California, that noted that that kind of approach had the twin benefits of, on the one hand, creating a real incentive for organizations to take security seriously and safeguard the information they collect, because nobody wants to go through the hassle, much less the reputational harm that can arise from a breach, and at the same time provide the public with the information they need to be able to take steps to mitigate against potential identity theft and the like. So we've seen it to a great extent in the United States. We still don't have it here in Canada, though it is included in a bill that is currently before the House. So there is a bill on that issue. More broadly, in terms of punishments, the Federal Privacy Commissioner, as an example, isn't able to do a whole lot from a punishment perspective for privacy breaches. In fact, what you typically get, and this is another source of frustration, I think, for a lot of people, you can file a complaint. If it is a well-founded complaint, after about a year typically of investigating, you receive a letter telling you that this is a well-founded complaint. So I had this in a case. I filed a complaint against the then Ottawa Renegades, CFL. They weren't very good, but they were still part of the Canadian Football League team, who spammed me a couple of times, and so it was essentially a test to see whether or not the current rules could be used to combat unsolicited commercial email. And so I get the letter, and the letter says, well, yeah, it was a breach of the law. And then the last paragraph says, if you'd like to go to court and do something further, you can go ahead and do that. And here's this is where that case will be heard. The federal courts hear these cases de novo. In other words, they hear them from scratch. And so after filing a complaint, waiting for a year, sometimes cooperating with privacy investigators, you're left with, if you want to do something more with just having a nice letter that I guess you can frame if you like, you actually have to now go to court and incur those legal costs and start from scratch. That's somewhat unsatisfying system, I would say, for a lot of people. It's actually, so my case is a little bit frivolous in the sense, I mean, it was just trying to look at spam, but instances of genuine privacy breaches, instances where former spouses gain access to medical information or banking information because the bank didn't do a good enough job of securing the account in terms of who's supposed to have access. I mean, you can look at the findings. There's lots of those kinds of cases. And those people are left with really nothing other than this well-founded finding letter. And so I think we ought to be able to do better.